On Monday, the United States Supreme Court will hear oral arguments in Cedar Point Nursery v. Hassid. California law allows labor unions access to Cedar Point's property to organize workers, and Cedar Point doesn't want to grant that access. They argue that the law violates their property rights and constitutes a taking of their property in violation of the Fifth Amendment. The Supreme Court has previously ruled that forcing property owners to allow beachgoers to cross their property constitutes a taking, so Cedar Point says that forcing them to let union organizers enter their property is a taking for the same reason. But in the beach case, the government allowed people to cross the plaintiff's property all day long. In the Cedar Point case, the union can only enter their property right before and right after working hours and during lunch break, and only during certain times of the year. That may or may not turn out to be an important difference. The Supreme Court was right of center even before Justice Amy Coney Barrett recently joined it. And it hasn't been very friendly to unions for some time, so there is a good chance that Cedar Point is going to win its case. The question is how far the Supreme Court will go. Conservatives don't like regulation, and getting the court to beef up property rights is high up on many conservative wish lists. If the court merely holds that the California law grants so much regular access to unions that it is an unconstitutional taking of property rights, just like in the beachgoers case, that will be only a mild win for the conservative cause. With a new 6-justice conservative majority on the court, many conservatives are angling for bigger fish. They want the court to roll back some major First Amendment rights. Various journalists have warned that the court could end up writing a decision that undermines the power of the government to enter private property in order to enforce environmental regulations and child labor laws. Another has even warned that the court could end up declaring basic civil rights law to be unconstitutional because they force businesses to allow racial minorities to enter their premises. That seems overwrought. In the case of civil rights laws, for example, those laws state that if a business chooses to let people onto their premises to, say, purchase a meal, they cannot exclude some of those people based on race, ethnicity, religious, and so forth. That's a very different situation than a business that doesn't want to let union organizers onto their property at all. But some conservative legal groups are pushing the court in this case to make some sweeping changes in constitutional law. Some groups, for example, have submitted briefs to the court asking them to use this case to overrule an earlier case called Pruneyard Shopping v. Robbins.